I'm attorney Susan Williams, and today we're going to be talking about a general timeline and the things that can happen in a juvenile case. Now, a lot of times when parents or guardians hire me to represent a juvenile, they've never been through the system before. They just need someone to help them along the way, step by step. So in the juvenile justice system, the Department of Juvenile Justice will be involved, and also the solicitor's office or the prosecutor will be involved. And first thing that will happen is that your child or the child that you are looking after as a guardian will get something called a pickup order. And that is something that is a piece of paper that the legal guardian signs that says, hey, we will definitely bring this child to court. You don't have to worry about us. So if that doesn't happen, then the child will be in jail and in the juvenile part of a detention center or a separate facility just for juveniles. And they will remain detained there until they have their detention hearing. At the detention hearing, the judge will determine whether or not they can go home or whether they have to remain detained. So sometime between when they're picked up and when they first go to court, ideally, they would either be assigned a public defender if they qualify for one, or someone will have hired counsel or lawyer for that juvenile. So after that happens, that lawyer will request, it's called a Rule 5 request, and it's under the rules of the criminal procedure in South Carolina. So the lawyer will get from the solicitor or the prosecutor the case file. And that would probably include things such as video or audio, if that's available, witness statements from other juveniles. Some of the stuff is like blacked out or deleted if it's confidential information about another juvenile. Sometimes it is, sometimes it isn't. It could be witness statements from other folks, that maybe teachers or parents if it happened at a school. So all of this stuff will be turned over to the juvenile's attorney. And by the way, the juvenile and the juvenile's attorney have the attorney-client privilege. So that means that everything that the juvenile and the attorney talk about is completely privileged. And even if the parent wants to know what is being talked about and the contents of the police report and the witness statements and the evidence against that juvenile, only the juvenile will be able to make that decision on whether or not the parents see that. So getting back to the timeline, after the juvenile and the attorney go over the evidence, ideally they would make some type of decision about whether the juvenile wants to plead guilty, which means that they did what they're accused of doing, or maybe the juvenile wants to plead not guilty. And in that case, they would be asking for a trial. Now, in South Carolina, trials for juveniles are completely confidential. They're not heard by juries, and they are held in the family court. And a family court judge would be the trier of fact and the person who instructs everyone who is determining the law in the case. So family court judge will hear what's called a bench trial, and the child will be able to testify if that's what is in the attorney determines in the child's best interest or what the child wants to do. And the attorney will have the opportunity to cross-examine the state's witnesses. The state can put up their witnesses and perhaps the alleged victim, if there is one, if it's a crime that involves a victim. If it's not, then their state's witness would usually be a police officer. And the defense attorney for the child will be able to cross-examine them, ask them questions, and then the judge will determine whether or not that child is guilty or not guilty and sentence them accordingly or let them go free. If the child is found not guilty, then of course this will be expunged. All juvenile records are typically sealed, and the juvenile courtroom is not a public courtroom. It is a closed courtroom in South Carolina where I practice. The doors are locked, or you're not able to even enter the courtroom. There are bailiffs waiting at the front, and you can't get past the bailiffs unless you are a party to the matter, a witness to the matter, but the state of South Carolina very much so respects the privacy of a juvenile. So if the child decides to plead guilty, then the judge will do a number of different things, whatever the judge decides to sentence the child to. A couple of things can happen. One is called a psychological evaluation, and that is an evaluation that is done by the Department of Juvenile Justice. And it can be either a detained evaluation, which means the child is detained in a juvenile facility, and it's like a juvenile jail basically for up to 45 days, or what's called a local evaluation. Now, a local evaluation is not detained. You will take your child to the evaluation center. The child will go through the psychological evaluation, and then you will pick the child up after the evaluation, as opposed to the child staying there for 45 days. Once the evaluation is completed, then you will return to court for the judge to review that psychiatric or psychological evaluation and determine what to do next with the child, whether maybe the judge may determine that they will put the child on probation, that they will do nothing and the case will be over with, or perhaps they will incarcerate the child for longer. For more information, head on over to my website at www.swilliams-law.net. I have some blog articles on there that I have written. And if you like this video and you found it helpful, hit like and subscribe to my YouTube channel. I'm Attorney Susan Williams.